Approaching on laws,
Okay.
is the last thing. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
Alright, this is.
Don't think there's a PC?
Laws.
No.
But,
Of course it has been,
right.
but there's new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through 2021 case. On October 5th, 2021, the officers were dispatched to a DWI call. The officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a U-turn on the highway, hit traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and a order full quiet, please, hold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address. And there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's,
But I thought for PC, we just used the DIMS because that was sworn to and not getting into the.
show me where it says that. I don't know of any rule that says that it's, PC has to be done on just the dim.
Okay.
You know, I don't, if you can direct me to something,
Okay,
but I've
and that just may
never,
be my misunderstanding of a
yeah,
policy.
I don't, and I've heard this before.
Okay.
Right, but I can't, I've never seen anything where someone has ever directed me to saying, hey, PC is only,
Well, it's
has to be just on the dims, you
because the
know?
DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into.
Sworn document too.
The offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using the DIMS, taking the offense report. And also, I have never seen it before where we have to rely solely on the DIMS for probable cause. It's probable cause. In fact, when we go to the grand jury, that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that, I mean, let's look, because I don't know, you know?
Okay.
And we came to with the district attorney's office, you know?
I'm not saying it's this, I'm just for curiosity.
Yes.
It's all true.
The DIMS has to state an offense, right? It has to say, it has to have all the
All right.
elements.
This is where things quietly get very serious up until now. This sounded like a routine DWI case, but what just came up is a constitutional landmine. The entire case is now hanging on one question. What counts as valid probable cause? Evidence, if the judge sides with the defense here. This isn't just a minor technicality, this could wipe out the case entirely. So let me ask you, should courts stick strictly to sworn documents, like the DIMS, or consider everything available, even if it's not sworn? Asterisk.
All the elements of the offense to go forward. The reason, I mean, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because you might get like 15 supplements.
And here's my question then for the court. And
Again, if
with,
you
I'm not
ask
saying.
and there it is, that's the moment everything flips. The judge just ruled no probable cause, not because the defendant was proven innocent, but because the process itself didn't meet constitutional standards. That's a huge distinction. In the legal world, how something is done can matter just as much as what was done. One missing detail in a sworn document and years of prosecution can collapse instantly.
With, I'm not saying we do this in this case. I'm just saying for cases going forward. To me, then, does that then behoove that say we can't take it to grand jury? I mean,
You can, of course you can.
so,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Asterisk interview asterisk. Now here's the twist that a lot of people miss. The case isn't truly over. Even though the judge shut it down here, the prosecution still has a second path, the grand jury. That means they can come back, present fuller evidence, and potentially revive the charges from scratch. So what do you think, is this justice working as intended, or a loophole that lets cases drag on indefinitely.
It's on them.
Yeah,
As far as me, I'm gonna just hold to the standard that we agreed with the county in the lawsuit.
I'm just, and this is for my own.
And you, look, you're not gonna hurt my feelings if you go to a grand jury. I don't
I know,
care.
I know you, Judge.
Oh, really?
So we wouldn't be held to that same
You need
standard.
to
at grand
do,
jury.
you need to do what you think is right.
Okay.
Like, I'm gonna do it, and like
Absolutely.
she's doing it. The problem is that whoever had the, perhaps they didn't dive into it and really look into it as